Human rights violations, Couran Cove, Gold Coast, Queensland, Australia. Broadwater electorate of David Crisafulli. What violations? People of Couran Cove have been without water, power, gas and sewage for more than a year and a half. What makes this a human rights violation? The International Covenant on Economic, Social and Cultural Rights, the ICESCR, under General Comment number 15, specifically states, under no circumstances shall an individual be deprived of the minimum essential level of water. The government has an obligation to protect. The obligation to protect requires state parties to prevent third parties from interfering in any way with the enjoyment of the right to water. Third parties include individuals, groups, corporations, and other entities, as well as agents acting under their authority. Where water services, such as piped water networks, water tankers, access to rivers and wells, are operated or controlled by third parties, state parties must prevent them from compromising equal, affordable, and physical access to sufficient, safe, and acceptable water. To prevent such abuses, an effective regulatory system must be established in conformity with the Covenant and this General Comment, which includes independent monitoring, genuine public participation, and imposition of penalties for non-compliance. You might ask, what is the minimum essential level of water? The United Nations General Assembly of the Human Right to Water and Sanitation recognized the right of every human being to have access to enough water for personal and domestic uses, meaning between 50 and 100 litres of water per person per day. The water must be safe, acceptable, and affordable. The water costs should not exceed 3% of the household income. Moreover, the water source has to be within 1,000 metres of the home, and collection time should not exceed 30 minutes. Why is Australia beholden to the ICESCR? According to the Department of Foreign Affairs and Trade, DFAT, Australia is a party to the International Covenant on Economic, Social and Cultural Rights, ICESCR. By ratifying a treaty, a country voluntarily accepts legal obligations under international law. Australia's obligations under ICESCR include regular reporting requirements. What about General Comment number 15 in particular? According to the Australian Government Attorney General's Department website, everyone has the right to an adequate standard of living, including adequate food, water, and housing, and to the continuous improvement of living conditions. Water. The United Nations Committee has stated that the human right to water entitles everyone to sufficient, safe, acceptable, physically accessible, and affordable water for personal and domestic uses, including consumption, cooking, personal and domestic hygiene requirements. Water and water facilities and services must be affordable for all. Everyone should have sustainable access to natural and common resources, safe drinking water, energy for cooking, heating and lighting, sanitation and washing facilities, means of food storage, refuse disposal, site drainage and emergency services. The UN Committee has stated that the right to an adequate standard of living and in particular to adequate food and water is necessary to ensure environmental hygiene, the right to health, Article 12, ICSCR. UN Committee on Economic, Social and Cultural Rights, General Comment number 15 on the right to water. The Australian Human Rights Commission on the right to an adequate standard of living including food, water and housing, specifically references Committee on Economic and Social and Cultural Rights, General Comment 15, the right to water. Are there no protections in Australia? Is Australia fulfilling these obligations? The Energy and Water Ombudsman Queensland, EWOC, website states, if you're experiencing financial hardship and are in debt with your water bills, your water provider cannot disconnect your water supply. However, they can severely restrict your water flow. Unfortunately, when reaching out to the EWOC, we are told that these protections do not apply to the residents of Couran Cove, and there's nothing they can do. There's the Water Supply, Safety and Reliability Act 2008 Queensland, which under Section 169 states, The service provider may reduce the water supply to the premises to the minimum level necessary for health and sanitation purposes of the owner or occupier. However, the service provider may not completely shut off the water supply to the premises. And under sections 530 through 532, provide the government powers to temporarily take control of water and sewage infrastructure if they stop being operated. Unfortunately, due to definitions, a water service provider, water service, sewage service, and a sewage service provider in Schedule 3 dictionary in this 400-page legislative document, these protections do not apply to the residents of Couran Cove. For Chapter 2, Part 3, the term does not include a service supplied by infrastructure if the owner of the infrastructure is a body corporate for a community title scheme, however described, established under an act, the occupants of the lots in the scheme. This may be reasonable for 398 pages of this legislative document, however, removes any protections to the people of Couran Cove, who, while they own the infrastructure, have no control over it. You may have noticed an important difference between the wording in General Comment 15 and with this legislation, where water services such as piped water networks, water tankers, access to rivers and wells are operated or controlled by third parties, as opposed to if the owner of the infrastructure is a body corporate for a community title scheme. The residents of Couran Cove own the infrastructure but have no control over it. The Australian government definitions fail the people of Couran Cove, whereas the definitions in General Comment 15 would protect it. We reached out to the Human Rights Commission of Australia and Queensland, who both said this was not a human right they cover or would get involved in. Albanese's office, who ignored our pleas for help, claims of human rights violations and inaction of the state government, responded with no mention of human rights violations and said they were referring it back to the Queensland government departments. Nothing more happened. We reached out to the offices of David Crisafulli, leader of the State Opposition of Queensland and Member of Parliament for Broadwater, the electorate of Couran Cove. Our pleas for help once again fell on deaf ears. We shared that this was an international human rights violation and requested a bill be put forward to fix this loophole to ensure that all Queenslanders are protected. They recommended we contact the Labor Party instead, who, in the end, turned out to be equally useless. The Australian government hasn't held up its international obligations and has left the people of Couran Cove to continue suffering. More than a year and a half of this suffering with only apparent apathy from the government. Not once have I seen David Crisafulli in his upcoming election campaign make mention of, let alone make any campaign promises to help the people of Couran Cove. Citations in the description or at humanrights.asn.au.